When demolitions occur and people are displaced, whose responsibility is it to cater for their shelter? We have to look at it from two lenses: the legalistic lens, which is the position of the government, and then the human rights lens, which is what many advocacy groups, especially human rights, fight for. And this is usually in line with the international standards. In Nigeria, when the property has a defective title, the government claims it does not owe any obligation. Now, why would the government say such? Number one, the illegality argument. The government usually argues that if a property does not have a certificate of occupancy, popularly known as the CFO, or a building permit, or is on the right of way, or even under government installations like a power line and so on and so forth, it means that the building or the property is an illegal structure. Number two, according to the Land Use Act of 1978, compensation is based on when the government revokes your title or interest in a particular land for public interest or for public use. What the government usually argues is for people with illegal structures, if you did not have a legal title, then there is no revocation in the first place, because we cannot revoke what you do not have. And so they stand by that argument, thereby not compensating or providing alternatives for those affected. Number three, at least for Lagos State, the public safety override. So a lot of authorities usually cite the Lagos State Urban and Regional Planning Development Law of 2019, which empowers them to remove properties that are deemed defective or hazardous. They argue that demolishing a slum which is built on a drainage can prevent flooding, which will affect the lives of the general public. This public interest overrides the private misery of these smaller communities. In this view, the government believes that it is not supposed to provide alternative shelter or compensation, because doing so would only empower irresponsible behavior and actions, illegality, and encourage people to build more slums. Contrary to the government stance, human rights law and international law states that the government is supposed to be responsible for alternative shelter for people affected, regardless of whether they have the permits or have the proper documentation or not. Understand that Nigeria is a signatory to the ICESCR. The UN Committee on this covenant has ruled that eviction should not result in individuals being homeless. It further goes down to state that if individuals are evicted and they cannot take care of themselves or cannot provide alternatives, the government must be responsible for providing alternative shelter for them. Otodo Gbame case, the court ruled that evicting people without providing an alternative shelter for them is cruel and inhuman, and it violates their rights as citizens, according to Section 34 of the 99 Constitution. The legality or illegality of a property does not cancel the fundamental rights or the rights of human beings, individuals, and citizens of a country. The government is supposed to provide emergency shelter. In reality, the government rarely fulfills this obligation. There are two things I need you to understand. The first one is the definition of a disaster. Agencies like NEMA and SEMA cater for the needs of people who are affected by disaster, be it flooding, fire, disasters like wars and what have you. They are tasked with creating supplies and IDP camps, internal displaced persons camp, where people can be housed and kept pending when they find their footing or when it is clear as to what should be done to those people. These agencies rarely classify government demolitions as disasters. In a case where flooding affects a community, these agencies will go there, set up and cater to them. But if that same community is being demolished because of, in quote, overriding public interest, or because the government has to put that particular location into alternative use for the good of the general public, then these agencies do not show up. Now, for me, it doesn't make any sense. And the number two thing I want you to understand is the resettlement myth. Even when the government claims to have resettlement centers, okay, they are either underutilized or repurposed or restricted to a specific kind of victims. For instance, victims of collapsed building. If You have victims of collapsed buildings there. You could also have victims of demolished buildings there. There are a lot of these resettlement centers. At least Lagos State has one in Igondo. Based on these arguments, if we agree that the government should care but doesn't, here are some actionable steps or some recommendations. Number one is it's time to codify the right to shelter. It means the National Assembly should try looking into the Kampala Convention and how it can be implemented in Nigeria. Now, what this simply means is that the rights and interests of IDPs, especially those affected by development projects run by the government, are protected. It curbs the way governors just approve demolition orders without them providing alternative shelter. Number two, look at upgrading. Not every community requires demolition. There are some that just require upgrade. And this can be done amicably and peaceably. Number three, those affected can also look at class action lawsuits. You are not just fighting for your land title alone or land ownership alone. You are also fighting for a breach in your fundamental human rights. Lastly, the government can also look into running a census before embarking on the demolition exercise. And the reason is simple. With a census, you have a clear picture of the number of people within a particular community. So if you have 1,000 people, for instance, you can make alternative 1,000 shelters for them. Because a person does not have proper documentation or lacks building permit or approval or what have you, that does not override their right to shelter and dignity.